This particular presentation we put together for you as a local board secretary, so you're aware of what the certain letters or minutes or forms that are necessary that we've talked about on all those spreadsheets and everything. So what I'd like to do is present various types of written correspondence that your local board may encounter, perhaps some agendas, do's and don'ts, and time constraints associated with this correspondence that we've referred to so far in the presentation. The types of correspondence that we normally have from the various 260 local boards are meeting notices. You know, we don't necessarily need to see those, but you, by open meeting law, needs to post those if you're going to have a meeting. Any agendas, that's something you'd post on your side, but we don't necessarily need to see those. But out of those first three items, we have to see the minutes of the meeting, any decisions that are made, anything of that sort. Any disability determinations you've made, also we need to see that in the minutes of the meeting in the correspondence. If you have any pre-existing notices that you send out to the members, we don't necessarily need to see those, but you need to have a file for each member that you've notified them that they had perhaps a knee injury or shoulder injury prior to starting with public safety. This is for your protection for your certain employer, so they can't come back and claim a disability at a later date. Okay? So with that said, these are types of correspondence we'd like to go through for just a minute. Your meeting notices can be very simple, very straightforward. You can have the following format with an agenda or without an agenda. That you're going to always, on your agenda item, have the date, time, and location of the meeting. You'd also call the meeting to order, and the date of the meeting should be right up on top. Any new memberships you might have, any disabilities, any retirements, anything that's going to transpire in that particular meeting should be listed on the agenda. Now you can take from that agenda and fill in your notes from your minutes of your meeting with any decisions that are made. It's always good that the local board members, make a motion for a particular action and then go through this process so it can be notated in the minutes with a vote on each particular retirement package. So what we wanted to do is some do's and don'ts with that. You do want to indicate all items which the board intends to take action on. In other words, if there's a specific topic or a certain retirement or anything you want to take action on, it needs to be on there. You do need to ensure that when you're going into executive session, you give a general description of the matters in which you're going to consider so it can be properly posted on that agenda. And you do need to have agendas available according to the open meeting laws for anybody who does come to the meeting. So these are just a little kind of a review of some do's that you do need to have available when you're transacting a particular local board meeting. A couple of don'ts is don't use generic agenda items as, we're going to go over some new business. Well, they want to be more specific on the minutes as we would like to read them, or other matters that might be coming up. You can't put that on your particular agenda or vote on anything if it's in that format. You don't want to take any action on an item at a meeting if it's not on the agenda. We had one group once that took action on an item that was not on the agenda, and we're like, you can't do that. It violates the open meeting laws. So you want to make sure whatever's on the agenda is the ones you're taking action on, and you don't have any other items or new business items coming up on the agenda. It has to be very specific. The minutes, all the minutes and decisions that are recorded on your minutes, here's a couple things to consider. The meeting minutes should include a general description of matter considered or discussed. You'd want to include a description of the legal action taken, including the members and the date of the action it's taken. And the action item must include the name of the official making the motion, and all people that speak must be identified and record the vote in the minutes of the meeting. Now, we've actually seen some minutes that come in and they say, Joe retired and we all approve. Well, is that good enough? The answer is no. You need to put the name usually, how much he's making. It's a normal retirement, or if it's a disability retirement. If it's for reasons of disability, you'd list why you've made the decision based off of an independent medical exam. In other words, the minutes of the meeting should be very specific of why each of those decisions are made with the retirement date. So we can read through the minutes and match that up against the retirement paperwork and say, yes, they've authorized us to do that. Otherwise, we can't just say, oh, Joe's retiring next month. Everybody vote on it. And so, again, that's to protect yourself, because those minutes of the meetings are here recorded, and they are being audited, and we do like to review those to make sure you're following all the protocols that we've just discussed so far today. Now, the copies of these minutes should always be received by our system within our office within 20 days of the date of the meeting. That's by law. That's set up in the statutes. That's just, if you send in the draft minutes, that's fine. But you do have to let us know that you've had some the minutes of the meeting do need to be sent in within 20 days. And minutes are supposed to be sent on by certified mail based off the law changes from a couple of years ago. That way we can record the date in which they came in, and they've been notified, notifications sent back to you that they've actually happened. This is particularly important on a disability retirement package, because sometimes there's timelines that need to be met, and we just want to make sure that's presented to you the way the law reads today. On your disability application, this is a very lengthy process, and we could go through a whole hour presentation, which you saw in the videos is available to you if you'd like to review that. But there are certain forms that need to be completed. We just want to kind of give you an overview. If you do come across one of these, this is what needs to happen. Initial letter and application notice is sent to the employee that, yes, we have this particular information from you. We're moving forward with the disability. You'd want a notice of a receipt and the appointment of the independent medical exam. In other words, that person's going to somebody who he normally hasn't seen before for a specific injury that occurred on the job, and therefore you're making a decision on your minutes of your meeting based off of that. Your medical records request, so why did you make your decision? So all that information is then presented. Request for the IME to go to that particular doctor. A notice to the employee on the local board meeting when the application is to be discussed and decided. In other words, we've had some local boards that voted on things and never notified the member, and you really need to let the member know what's actually happened, whether he's had a disability or a normal retirement, whatever it might be. It's just good to safeguard for your protection to notify the member. And then obviously if you're going to notice any decision that you're moving forward with, the member would need to know as well. We briefly discussed this earlier, but I want to make sure we make a point of any pre-existing notifications. Your board should acknowledge any pre-existing condition for any new member that you have. Upon a decision of your membership accepted with a pre-existing condition, you should notify the member in writing. And this assists him with a written record, and a decision is then put in the member's file. There's so many times if you don't notate that and put it in the minutes of the meeting that it had a pre-existing condition, the person, as we mentioned, could come back for a disability application. So it's a good safeguard and protection to always notify that individual in writing of any pre-existing condition. As we'd mentioned before, too, that you can have a template for that, just a notification so you're aware and they're aware that that's happened. A pre-existing example of a letter might particularly say you put the officer's name and address, the last name of who it might be. Public safety is aware of this information pursuant to a certain law. This is the date, and we're aware of that's what's happened within based off the medical evidence that you've gotten, or based off the pre-existing condition letter. So again, you can put those in a member's file and make sure they're available at any time if they're needed going forward. Other documents and forms to consider. Some additional documents you may want to create or templates or have handy is a notification of surviving spouse, guardian, or child benefits. Those are always nice to have a template available. A request for a full-time student status. In other words, perhaps the father's passed away, the mother's passed away, but there's an eligible child that may be going to school, and you want to make sure that you know that they're in school so they're entitled to those benefits. And perhaps an oath of office of any newly created elected members on the local board. So we don't necessarily need to see those oath of offices anymore, but you need to have a file that if someone were to come out and audit you, to say, yes, we have these on file. So we are working against the clock, as we'd mentioned. Certain forms and documents have statutory requirements. Notice of any action that you have from a public safety point of view, like a normal retirement or disability or anything, 20 days after business has occurred, make sure you send that to our office. Decision on any application that's happened or your oath of offices, after 10 days after the person might be elected to the board and able to serve, you should have those in your files within 10 days that the oath of office has transpired. Also, the agendas 24 hours in advance need to be posted prior to the meeting, and any modifications after that needs to go on the next agenda items for a subsequent meeting. So these are just kind of things you need to be aware of as local board secretaries as you prepare the minutes or the agendas for your meetings. Any questions so far? If the minutes are sent in a little late, there's two consequences. If we don't have the minutes to compare to the retirement now, the person may not get paid. Even if you have draft minutes, send those in first. We are trying to make sure every time a retirement happens and we make a payment, by law we have to authorize or see authorization from the board. So we have had situations where the minutes didn't come in, the person didn't get paid, and guess what? The member wasn't real happy. Okay? Can we send minutes by email? The answer to that question is no. There used to be a time a few years ago that we could accept that, but the tradition and that policy has been changed because the law has changed. And they do need to be sent on by certified mail now. Thank you for that question. Again, we wanted to make sure you had our contact information for not only the local board training department, but also active members and retired members group. Well, we appreciate you coming in today and attending our webinar on local board secretaries, duties and responsibilities. Feel free to email us any other questions or concerns. Thank you. That concludes our session for today.